ਅੱਜ ਬੜਾ ਖੁਸ਼ ਨਸੀਬਾਂ ਵਾਲਾ ਦਿਨ ਹੈ। ਉਹ ਕਿਵੇਂ ਤੇ ਕਿਸ ਤਰ੍ਹਾਂ ਦੇਸ਼ ਦੀ ਖੁਸ਼ ਨਸੀਬੀ ਨੂੰ ਕਿਵੇਂ ਚਿਤਰਿਆ ਜਾਂਦਾ ਹੈ, ਪਰਮਾਨਿਆ ਜਾਂਦਾ ਹੈ, ਨਿਹਾਰਿਆ ਜਾਂਦਾ ਹੈ, ਲਿਖਾਰਿਆ ਜਾਂਦਾ ਹੈ, ਤਿਰਸਕਾਰਿਆ ਜਾਂਦਾ ਹੈ। ਤੁਸੀਂ ਇਹ ਦੇਖੋ, ਅੱਜ ਖਬਰ ਆਈ ਹੈ ਟ੍ਰਿਬਿਊਨ ਦੇ ਵਿੱਚ 1992 ਤੋਂ 925 ਕੇਸ ਜਿਹੜੇ ਨੇ ਕੌਨਸਟੀਟਿਊਸ਼ਨਲ ਪੁਆਇੰਟ ਆਫ ਲਾ ਨੂੰ ਡਿਸਾਈਡ ਕਰਨ ਲਈ ਤਰਸ ਰਹੇ ਨੇ, ਤੇ ਉਹਨਾਂ ਨੂੰ ਤਰਸ ਨਹੀਂ ਆਇਆ ਜਿਹੜੇ ਸੁਪਰੀਮ ਕੋਰਟ ਦੀਆਂ ਗੱਡੀਆਂ ਲੈ ਕੇ ਤੇ ਇੱਥੋਂ ਨਿਕਲ ਗਏ, ਤਲਾਂਜਲੀ ਦੇ ਕੇ ਨਿਕਲ ਗਏ। ਇਹ ਵਿਚਾਰੇ ਉੱਥੇ ਹੀ ਵੇਖਦੇ ਰਹਿ ਗਏ। ਇੱਥੇ ਗੱਲ ਕਰਦੇ ਹਾਂ, ਅਨਿਲ ਭਾਟੀਆ ਪ੍ਰੋਫੈਸਰ ਸਾਹਿਬ ਆਏ ਨੇ ਸਾਡੇ ਨਾਲ, ਉਹਨਾਂ ਨੂੰ ਪੁੱਛਦੇ ਹਾਂ ਵੀ ਇਹ ਕੀ ਹੈ ਸਾਰਾ ਕੁਝ।
Bhatti Sahab, the Indian Constitution envisages three pillars of democracy, that is legislative, executive and judiciary. And another pillar, that is media, has just been tagged having lost its credibility, be it print media or electronic media, because it has been overpowered by social media. Now the question is that what is the role of our executive, legislative and judiciary? Politicians have failed the people miserably and people have failed the country. The executive or bureaucracy is selfish, greedy, apathetic, indifferent, and they watch only their self-interest. Let the people go to hell. So the only hope which remains for a common man is judiciary. But even judiciary is guilty of dereliction of duty, maybe because they are overburdened, or maybe that they are indifferent, and to some extent they are inefficient and incompetent also. There was a news today in the Tribune that around 925 cases are pending since 1992 about the constitutional matters before the apex court of this country. And these cases have been pending before a 5-judge bench or a 7-judge bench or a 9-judge bench or an 11-judge bench. But now the question is that when the apex court says that we lay down the law for the entire country and their judgments are the binding precedent, but I have seen and observed in various high courts of this country where the judges of the high courts openly say that we shall not abide by this judgment and this judgment is not a binding precedent on us. So there is a kind of conflict which is going on between the various high courts and the apex court also. Now only lately the apex court has taken a very serious note of thousands of special leave petitions being filed in the Supreme Court of India, and they have taken to task the high courts also, that since the high courts do not deliver justice in accordance with law, that is why the apex court is burdened with all kinds of frivolous, useless and unnecessary litigations on even flimsy matters, not to talk of the issues which are concerned with the entire country. Even on small issues, everybody goes, if he is aggrieved of the order of the High Court, he will go and file an SLP. Now the question is that how we can streamline the administration of our country. Judiciary has a great responsibility to give justice, because law is nothing but justice, and justice is fairness. Law is science of what is true and what is unjust. But what I have experienced and observed in our country is that the rule of law is not being followed, and that is why people have been running from pillar to post to get justice. Now people have no fear of law. If there is a dispute regarding some service matter, the man who is holding the office, he will say you go to the court of law and you will waste your entire life and nothing good will come out of that. So that shows the lackadaisical attitude of all the three pillars of democracy, be it legislative, be it executive, or be it judiciary. But to my mind, all these three wings of democracy should work in unison, and they are duty bound to inculcate faith in the people that we shall abide by the rule of law and we will do everything in accordance with law. But nothing of that sort happens, because here in our country, to quote Shakespeare's Hamlet, fair is foul and foul is fair. Right is wrong and wrong is right. And that is why people continue to suffer endlessly without any result whatsoever.
It means that 17.5 lakh people have said bye to the Indian citizenship of India. That is the reason which is leading to it, and they too are enough rich. And if I say millionaire or billionaire or trillion, they have shifted to other countries while saying bye to this country. This is the reason, and what is the accountability for it? What do you feel about it?
Of course, Bhatti Sahab, the old adage, might is right, it still goes on in our country. Not only lately, there has been a movie going on in Netflix entitled Black Justice by Kapil Kakkar. And he has raised a very pertinent issue that about 5 crore cases are pending in various courts, be it High Court or Lower Court or Apex Court. And besides these cases, several crores of cases are pending in various tribunals also, and they are pending in various commissions also. Now, if you calculate that 5 crore cases are pending in high courts and lower courts and session courts and apex court, it means ordinarily, if there is one case and there are 6 members in that particular family, that means 30 crore people have been suffering because of the lackadaisical attitude of our judiciary. So this is a very sorry and shoddy state of affairs. But judges don't bother about the grievance or problems of common man. They are concerned with their post-retirement benefits. They are concerned with their own perks and privileges. Let the people go to hell. Now, we are the masters, we are my lords. So we have no accountability, we have no credibility, and there is nobody to challenge our authority.
Even after retirement, the High Court judges are prefixing justice instead of justice retired. Is it correct?
Yeah, of course. You see, this is nothing. This shows that they have a very self-centered attitude. I am reminding of a joke that a research scholar did his degree, PhD degree in 4 years, and he used to buy things from a grocery store without paying anything, just giving him assurance that when I get the degree of PhD, I will give you the money. The day that research scholar obtained his degree of PhD, he went to that shopkeeper and he said, "You open my account." The shopkeeper was very happy that today he is going to recover his amount. And he said, "Sir, you owe me around 12,000 rupees during the last 4 years. He said, "It is okay. Now, before my name, you add the word doctor. That is all." And the matter ended there and then. So this is the scenario in our country.
You have just talked that officer make an employee to suffer, and the Honorable Supreme Court in 2022 last year delivered a judgment on public accountability, what the governments are doing and why they are mute spectators over their such bureaucracy and officials of executive, including the legislative people.
You see, Bhatti Sahab, about 15 years back, I was arguing a case before a very learned judge of Punjab and Haryana High Court, who later on became judge of the Supreme Court also. And I very humbly made a request to him, "My lord, why don't you issue a directive to the Secretariat that they should follow the rule of law and they should act in accordance with law?" And that judge looked at me and said smilingly, "Well, Professor, do you want me to die of hunger?" Do you want these advocates to die of hunger? Let these bureaucrats commit illegalities and irregularities, and we are having a gay time and a gala time because of these reasons. So this is a very non-serious kind of attitude because nobody wants to own any responsibility.
Till 1983, the Supreme Court used to deliver judgments within a year or two. Now it is taking enough time. Even the high courts are burdened with such pendency which is never touched during the last 30 years or 35 years. And the high court judicial clock shows daily this is the disposal, and disposal means dismiss and default on merits in limine or what it is not categorizing anything. Do you feel it is not, you see, a judicial mischief?
Of course. And Bhatti Sahab, I have gone through various judgments of the various high courts, and I consider that these are not judgments, these are simply orders, because the high courts do not bother to decide a substantial question of law. And for this, it is not only the bench which is responsible, it is the bar also which is responsible. Because majority of the advocates believe in seeking interminable adjournments. To my mind, no case should be adjourned for more than 2 times. And on the third date, the case has to be decided after arguing it properly as per rules.
I have come across in the last week a case wherein the counsel addressed arguments, and when the order came into being, it was shown none present. In the interest of justice, adjourned to such and such day. What do you feel about
This is very unfortunate, and this is a reflection on the malfunctioning of judiciary also, and that shows their incompetence and inefficiency also.
And if this being so, it means it is a contributory negligence, or it is a attribution or aggravation to certain circumstances which we have just discussed.
No, it is not a contributory negligence. I will say that it is an intentional mistake, not even unintentional mistake on the part of the court.
For deliberate mistakes, the Honorable Supreme Court in 1972, Supreme Court page 2466, said it amounts to contempt. And the gone are the days when the judges used to issue such orders, and even a superior judicial officer from Odisha in that case was ordered to be dismissed by the Honorable High Court. Now, the High Court and Supreme Court is protecting the subordinate judiciary, and what kind of superintendent power and control as enunciated and enshrined under Constitution of India, Article 227. You have
Well,
to say.
Bhatti Sahab, you have used the word contempt of court, and I personally feel that most of the judges now, they hide themselves behind the Contempt of Court Act because they know that they have no other power but to use this Contempt of Court Act. Nothing of that sort. Now, only a few days back, a judge of Delhi High Court has been transferred to Odisha High Court, and he has refused to join his duties there, and the apex court has no power whatsoever to reprimand the judge of the High Court. He says, you send me to a neighboring state. No, it is an all India service. So why a judge of one particular high court should refuse to go to another high court? He is a judge, whether he is a judge of A high court or B high court or C high court. He should deny that. But they say, no, we are the my lords, we will have our say.
In that, how do you earmark a distinction, choose and choice?
Now this is not only pick and choose, this is whims and fancies also. Whims and fancies also. And the quality of judges we have nowadays, now people say we are ashamed of the quality of judges we have.
One time Justice Krishna Iyer and on another occasion, the Supreme Court judge said, go in the Supreme Court lawns and check your credibility while discussing with the people whosoever is visiting to the premises of Supreme Court. Was that correct observation?
Well, Bhatti Sahab, gone are the days when we had judges like Justice V. Krishna Iyer. They were the real judges. They were the real legal luminaries having a sagacious wisdom. Nowadays, judges do only cut and paste work without applying their mind, and most of the orders are non-speaking and they show non-application of their mind.
I am pointing out one judgment of Justice Krishna Iyer. He was sitting along with two judges, Matthew Saab and Ray Saab, Chief Justice. And he concurred regretfully within the bracket. Regretfully, then he expressed, and he advised the Parliament must perform its wisdom, and now the wisdom of the Parliament has gone. He feels it is correct.
Well, you see, under the constitution they say Parliament is supreme, and the job of the apex court is to iron out the creases in the law. So they cannot lay down law, but that is the duty of our parliamentarians also, that whatever laws they frame, that should be for the benefit and welfare of the people and not for their own personal benefits.
I am pointing out two instances. Lord Justice Dining way back in 1949, All England Law Reporter, page 155, it says the court is duty bound to interpret what is within the language of the lines. Is it correct?
Yes, of course. Any statute which creates chaos or absurdity or which is conflicting, that statute has no legal sanctity at all. And in the end, Bhatti Sahab, I would like to say that to perpetuate an error is no virtue, but to rectify the same is the compulsion of judicial conscience. Now I am using the word judicial conscience because our executive and our legislative, they have lost their conscience. They don't have inner soul and they don't bother whatsoever about the people of this country.
Post-retiral benefits is an incentive and it must go for the sake
Of course, for that judges have to introspect. That where do they stand? Are they at the mercy of the politicians or they are meant to deliver justice to the common man? That is for them to do soul searching and introspection.
It is an expression of speech which has been expressed by way of the virtue of the Constitution of India for the welfare of the state, for the welfare of the people and for the interest of the people of India. So therefore, thank you, sir.
Thank you very much,
For
sir.
joining
I'm
me.
obliged. Thank you. Thank you so much.
Hold on. 1548.